A shocking attempted murder in the UK sparked a years-long international manhunt, and it all culminated in the sentencing of the woman who carried it out. We're going to break down this absolutely bizarre story of how American woman Aimee Betro became embroiled in this case, and we are going to speak with a UK criminal attorney for insight into how cases like this are investigated and prosecuted. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. After years on the run and a high-stakes international manhunt, an American woman finally faced the courtroom in the UK and the possibility of a decades-long sentence hanging over her head. Now, in case you haven't been following this, okay, we got to rewind. This is a wild ride, to say the least. We're going to take it step by step, okay? This sounds like it's from a movie. It's not. We're talking about Aimee Betro. This is a Wisconsin woman who once posted online about relocating to London. But, instead of chasing a new life abroad, she found herself entangled in an assassination plot that would make her the target of an international manhunt. For years, she was a fugitive at the center of a global search. How did she get there? Let's talk about it. Now, according to reporting from the BBC, Aimee was from West Allis, Wisconsin. And she lived a pretty ordinary life on paper. She had been a pet sitter, a graphic designer, even a top sales representative for the Milwaukee Brewers ticket office. On her LinkedIn, she mused about music and travel and wanting to relocate to London or California, dreams that, strangely enough, would take a very dark turn because at around 2018, Aimee met Mohammed Nazir on a dating app, began making trips to the UK to see him. Nazir and his father, Mohammed Aslam, they were caught up in this violent feud that happened at this clothing store, a fight. And police later said that it was revenge that consumed them. And Aimee apparently became the weapon that they tried to use. By September of 2019, Aimee was allegedly part of their plan. You can see in this video from Midlands Police on September 7th, she is disguised in hijab, waits outside the home of the man Nazir wanted dead, and when he arrived, she raised a gun to his face, but miraculously the gun jammed. A miracle. It's incredible. Now, instead of abandoning the mission, what does Aimee do? She returns hours later and fires shots into the house. To drive the fear home, she also apparently texts the victim's father a chilling message. According to police, it read, "Stop playing hide and seek. You're lucky it jammed. Who is it? Your family or you? Pick one." Wow. All right. So the next day, Aimee was spotted on CCTV footage at the airport, flying back to Wisconsin. Nazir apparently slipped out of the UK too. Together they took this bizarre American road trip, Seattle, San Francisco, Las Vegas, even a stop at Area 51 in Nevada. This is all before they vanished. And by the time investigators tied her to the crime, Aimee was gone. For the next 5 years, she was an international fugitive. In June of 2024, her own mother told The Telegraph that she was begging her daughter to turn herself in, warning that she had nowhere else to go, and admitted she would call police if Aimee showed up at her door. Now, the big break in this case came in the summer of 2024, and it was actually thanks to the efforts of the media, particularly the Daily Mail. The outlet reports that through its own investigation, it was able to tip off police to Betro's location in Armenia and agreed to halt covering the case so that the police could zero in on her and extradite her back to the UK to stand trial. And by the way, we didn't just take the Daily Mail's word for it. The BBC also reported on what the newspaper did here. So when Betro finally faced a jury in Birmingham, do you think she was accountable for her actions? Do you think she took responsibility? No. The Daily Mail reports that her case was filled with nothing but denials of some really hardcore evidence. DNA, CCTV footage, there was a rare American pistol that no one in the UK had ever seen before, apparently. So let's get into this, but first, to help me break all this down, I want to bring on a special guest who's joining us internationally from the UK, criminal litigation attorney Nick Brett. Nick, thank you so much for coming here on Sidebar. Really appreciate it. Let's start right here. What are the key legal requirements when what we're talking about when we're saying extraditing an American citizen to the UK? Either it's from, the US or Armenia, wherever it might be. What are we talking about?
Well, I mean, we have a bilateral agreement with the United States and have done for many years relating to extradition, which is something that seems to function extremely well. Effectively speaking, as with most extradition treaties, what there needs to be is a basis for suggesting that there is evidence that somebody has committed a crime and for which they ought to stand trial in the UK.
What a case, I know. But this is definitely one we wanted to bring to you. And the reason that we can do that is because of the amazing support that we get from our sponsor, Morgan & Morgan. This is America's largest injury law firm. This is a firm with over 1,000 attorneys. You know why they're so big? Because they win a lot. They have recovered over $25 billion for more than 500,000 clients. Think about that. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million. That's after being offered only $500,000. And even if you think your case isn't worth, millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan, they make it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen.
And, as I say, there is an agreement between the United States and the UK regarding the extradition of suspects both ways. And so recent examples of those that have gone to the United States, Mike Lynch, who was notoriously tried in the United States for fraud and acquitted, and then subsequently died in the yachting disaster last year. So really, there is a quite effective agreement between the United States and the United Kingdom with respect to the transfer of suspects for criminal prosecution.
In other countries, has that become a little bit more difficult? Again, like we're talking like with Armenia or
It
something
really
like that?
depends on the country in question. So we have an agreement with all EU nations regarding extradition. We then have separate treaties with other countries outside of the EU. And so, for example, presence in certain countries, Pakistan, Saudi Arabia, it would be more difficult for the UK government to seek the extradition of suspects who are hiding in those countries than it would be, for example, to come to go to France and to ask the French to extradite, and similarly, with the United States.
So now you have all this evidence in a case like this, and if it goes to a UK court, we're talking DNA, we're talking CCTV footage, we're talking a foreign firearm. A, what do you make of this kind of evidence? And B, are there special rules for how this evidence can be admitted and used at a trial?
Well, there are rules relating to the admissibility of evidence in the United Kingdom. And so forensic evidence, for example, needs to be introduced by what we would determine to be an expert witness. So somebody who has the relevant experience to introduce that evidence and then to produce reports of their examination. So DNA, for example, is frequently used in criminal trials in the United Kingdom. The examination of DNA is undertaken by specially trained experts with experience, who will then produce a report of their findings. Sometimes there can be question marks about the admissibility of expert evidence on the basis that there is a challenge to the expertise of the witness in question. Although I'm not aware that there were any such challenges in the Betro case.
Talking about her case, I'm going to get into her defense in a second, but one of the things I wondered, would a defense of, let's say, coercion or duress, could that be raised, right? She was acting under pressure from Nazir or his father, or did she really have a sense of autonomy here and that wouldn't work?
Duress is a defense to certain crimes, including murder, in English courts. It is a notoriously difficult defense to run. Duress really requires the persuasion, so the burden would shift to the defendant to persuade the jury that they had no other choice, because they felt that they would lose their life or the life of a close one, if they didn't act in the way in which they were told to do. I mean, in a case like this, bearing in mind that Betro was outside of the jurisdiction before she came here, it would obviously be a difficult defence for her to run.
Let's talk about the defense that she did run with, because in court she denied everything, everything, despite being, presented with CCTV footage, DNA acquired from a glove in the Mercedes that was used in the shooting, a witness describing a short, fat American woman, and they even traced this gun, this rare American high-point pistol, reportedly has never been seen before in the UK. That weapon was never recovered, but ballistics experts determined from footage that was the weapon that was used. Nick, how compelling, let's start with this, how compelling is CCTV footage in UK criminal trials when the defendant is disputing identity or involvement? It seems to me, when we're talking about footage of her after the shooting, another of the shooter with a gun drawn, her in the area, her at a McDonald's after the shooting, felt like pretty tough to argue against.
Exactly. I mean, CCTV evidence is a very common feature in trials in England. I'm sure it's the same in the United States. And real expertise has developed over the identification of suspects using forensic techniques to ensure that really comparisons are can be proven beyond a reasonable doubt by relevant characteristics and measurements of size of head and body. So there are all sorts of techniques now, which mean it's very, very difficult for any defendant, to deny their presence on CCTV unless the footage is really quite poor. I mean, obviously, CCTV footage does vary in quality. I think that as time goes on, CCTV is getting more and more advanced. But certainly techniques have improved radically over recent years.
And the firearm I thought was interesting, right? If a firearm was never recovered, but experts identified from footage and ballistics, and they're saying this is a firearm that really has no presence in the UK, I thought that was significant.
Yeah, well, I mean, firearms are not prevalent in the UK, as you know. There are very strict laws around the possession of firearms. If one is found in possession of a prohibited firearm or prohibited ammunition, then minimum sentences of 5 years apply. And so there are very, very strict laws against the possession and use of firearms in this country. And therefore, I think it does make it easier for a ballistics expert in the UK giving evidence for the prosecution to identify that particular firearms would be very, very unlikely to have come from any other particular source or used in any other particular incident simply because of their scarcity.
And it's amazing that they can determine what the weapon is, not even by looking at it, I mean, not even having it in their possession, but seeing it from footage and able to determine what that might be and through the ballistics evidence. I always find that fascinating.
It's incredible.
Yeah,
Yeah,
no, please, Nick.
sorry, it's incredible. Yeah, and obviously examination of bullets themselves can determine, as a result of the markings on those bullets, how they were discharged and from what weapon they're likely to have been discharged from. So yes, again, it's a very, very developed area of expertise.
By the way, I believe this was a jury trial that she had. And if I'm correct about that, what is the framework of it? How does it structured? Is it, the prosecution goes first, they call their witnesses, the defense has an opportunity to question the witnesses, the defense puts on a case, it's sent back to deliberation. Do they have a limited amount of time that they can deliberate for? How many people are in the jury? What does a trial typically look like in the UK?
Well, you've summarised it pretty accurately. First of all, a jury is impaneled. We call it impaneling a jury. So there is a group of, say, sometimes 60 people who've been called up for jury service to a particular court, and 12 of them will be selected, and they will be asked various questions to ensure that there is no reason why they may be prejudiced in any particular case by, for example, knowing the defendant or any of the witnesses, or having some particular interest which is relevant to the trial, which may affect the way in which they deliberate. And once the judge is satisfied that he has a jury of 12 people, they're sworn in. And once the jury is sworn in, the prosecution opens the case. So that means that a barrister instructed by the prosecution reads what's called an opening speech. I'm setting out what the prosecution say about the case. The defence don't have any part to play at this juncture, and the prosecution will then call their witnesses. So first of all, they'll call their first witness. Quite often in a case, a complainant, so somebody who is the victim in the case. They will give evidence in chief, which means it's the evidence which they are giving for the prosecution, and then they will be cross-examined, and then the defence get an opportunity to cross-examine each prosecution witness until the prosecution closes its case. And once the prosecution closes its case, the baton goes over to the defence, and it does happen sometimes, but it is quite rare for there to be defence opening speeches. The defence would usually call the defendant, if the defendant wishes to give evidence, so the defendant's not required to give evidence, and then that defendant gives evidence in chief, is then cross-examined by the prosecution, and the defence will then call any other evidence that they wish to call. So sometimes expert witnesses, if those experts haven't been agreed in writing before and read before a jury, or other witnesses of fact or even character for the defence. And then there is at the close of the defence case, a prosecution closing speech, and then finally a defence closing speech, and then the judge will sum up the case to the jury. So it's a process called summing up, in which he sets out both parties' cases, and he sends the jury out first of all to find whether or not they can reach a verdict on which they all agree. And if they can, and there's no actual time limit to how long the jury is given for that. It will depend on the case and the complexities of the case. So, for example, a long-running complex fraud case would mean that the jury would be given much more time than, say, a much shorter case involving shoplifting, for example. And if they can't reach an agreement upon which they all agree, they can then be sent back out for what's called a majority direction. So that is a direction upon which at least 10 of them must agree. And if at least 10 agree, so either 10-2 or 11-1, then that verdict is entered. And if they can't reach a verdict, then they have what is known as a hung jury, and the jury is discharged, and then the prosecution can decide whether they wish to prosecute again at some stage in the future.
That's amazing. So wait a minute, they don't necessarily always have to be unanimous, as long as you get a majority. Is that always the way it works? It's like, does a judge say that, hey, listen, by law, I have to now send you back to just get a majority? Or will some judges say, hey, listen, if I couldn't get unanimous, that's it?
Well, no, a judge ordinarily would, unless there was some exceptional circumstance, would ordinarily, if a jury can't reach agreement, sometimes the juries send notes. They can send notes to a judge, and sometimes, there are circumstances on which the foreman, so there's a foreman of the jury appointed, may say there's just no prospect of us ever being able to agree because we're split.
But you could get a verdict. You could get a conviction just on a majority.
Just on a majority, but it has to be minimum of 10.
Minimum of 10. Yeah.
Minimum of 10. Either way. Right. So either in favor of conviction or acquittal.
Interesting. That's interesting. I didn't know that. Okay, so let's talk about this. So the jurors here, they learned a lot more. They learned a lot more about Betro's relationship with Mohammed Nazir. And per the BBC, the pair had apparently texted and video called regularly. She even visited Nazir a few times in 2018 and 19. And as for why she seemingly agreed to commit this murder, this attempted murder, prosecutors alleged she was smitten. She was smitten with Nazir. Nick, let's talk about that. That was an interesting motive in this case.
Very strange. It was of course a conspiracy case. So a conspiracy in England is an agreement to commit a crime, and so they obviously reached, as you say, a certain point in their relationship where he had a I would imagine some form of hold over her as a result of her emotions towards him. And, you know, it would appear that it was that caused her to behave in the way that she did.
And on August 12th, after almost 24 hours of deliberations, that jury convicted Betro of conspiracy to commit murder, possessing a self-loading pistol with intent to cause fear of violence, and illegally importing ammunition. And on August 21st, she was sentenced to 30 years in prison. Nick, did they get it right?
Well, I mean, I read the judge's sentencing remarks, and he was quite careful to make a comparison with the guidelines. So judges have guidelines for attempted murder, and he considered. I mean, this was really an attempted murder case because obviously there was a problem with the discharge of the firearm, such that it meant that, you know, had that not happened, there may well have been a fatality. And so he was quite careful to make the comparison, first of all, with those sentencing guidelines, because there are no sentencing guidelines for conspiracy to murder, it being quite an unusual charge. And he also was obviously able to make comparison with the sentences that he passed last year on the father and the son. And then he passed the separate sentence on the other two firearms offences, and so the upshot is that she serves 30 years. Well, the sentence was 30 years imprisonment, of which she will serve two-thirds, 20.
You mean a minimum, right? Or could she theoretically get served out the full 30?
She could. I mean, ordinarily she would be released after the two-thirds point on license, and so that means that she remains subject to recall in the event that she would commit any further crime in that further period of 10 years.
It's interesting when you think about that. Was there any kind of mitigating factors? I don't know, lack of prior criminal record, emotional manipulation. Could that have been considered as a mitigating factor?
I mean, there's always mitigation, and I think there probably, you know, were those kinds of factors in this case. But the problem is that the crime is so serious that I think personal mitigation, usually in sentences of this nature, has little real bearing on the overall outcome. I mean, credit does. I.e., that if a defendant pleads guilty to a crime, then he or she is entitled to a discount, depending on when they plead guilty, of up to 30%. So a reduction in the sentence would otherwise have been imposed after a trial, with the thought being that, you know, it saves the state time and money if they don't have to go through with the prosecution.
But to you, it makes sense, the jury's verdict, right? That she was convicted based on the evidence that was presented against her?
Yes, it does. Absolutely.
Yeah. And could she appeal?
She could appeal. If you're going to appeal against your conviction or sentence, you need to make that application within 28 days of the decision. Your application is made in writing, first of all, for permission to appeal, and it goes in front of a single judge sitting in private, so not in an open court. He makes a decision whether or not to grant permission. If he refuses, you can renew that application before the full court, which is 3 judges. If he grants permission to appeal, then the matter is set down for a hearing in front of 3 judges in the Court of Appeal, which is based here in the Royal Courts of Justice in London. And they would then determine, on the question of conviction, whether or not, in all the circumstances, that conviction was safe, and on the question of sentence, whether or not the sentence was manifestly excessive.
And that was interesting that you talk about the sentence because of your conversation before when you talk about the severity of the gun laws in your jurisdiction, right? The idea of possessing a self-loading pistol with intent to cause fear of violence or illegally importing ammunition. The judge was looking to these very serious crimes to help determine what should be the appropriate sentence in this case when looking at conspiracy to commit murder. Those are incredibly serious charges, right? The idea of the ammunition and the possession of the weapon.
That's absolutely right, and you'll see that he imposed concurrent sentences with respect to the second and third charges. What that means, concurrent sentences, is that they are actually served along at the same time. So he would have considered what is called a principle called totality. So he would have considered what was the overall sentence that he passed, commensurate with the criminality, the overall criminality in the case, and he formed the view that the 30-year sentence was the appropriate one to pass in the circumstances.
Well, following Betro's sentencing, Detective Chief Inspector Alistair Orenkus of the West Midlands Police told the BBC this is a unique case which has involved a huge amount of work tracing the movements of Betro from her arrival into the UK, her subsequent failed attempt to shoot a man dead, and her departure from the UK. It's by luck that her attempt to kill her target failed, thanks to the jamming of her gun, and an incredible amount of work went into building up a really detailed picture of her activities while in the UK. We work really closely with partners such as the American government, NCA, FBI, Crown Prosecution Service, and the Derbyshire Constabulary to bring Betro back to the UK to face justice. You know, Nick, I think that really sums it up well. This is a unique crime. You had all of these different agencies working together to seek justice. This was taking many years. What do you think about how this all concluded?
Well, I think that the National Crime Agency, for example, would have been involved in the extradition process, which it seems to me was fairly long and convoluted, because she was certainly in custody in Armenia, wasn't she, for, I think, nearly a year or maybe 6 months or so. So, unquestionably there has been coordination, as there often is when, such a serious crime has been committed. Police resources do tend to be, properly focused on ensuring that where lives are put at risk in this way and where firearms are concerned, that appropriate dedication is placed to ensuring that all of the culprits are brought to justice. And of course, there was a previous case involving the father and the son last year who both received fairly substantial prison sentences.
What a saga. Nick, thanks so much for coming on. Really appreciate it. It was great seeing you.
Thank you, Jesse.
You got it.
Nice to see you. Cheers. Bye.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.